Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. Moorish Empire, traveler on the land, bitch snitch, Moorish Empire, God dang, you're right, traveler on the land, bitch snitch, the late evening U.S. people,
into the mud, scum queen.
That's right. We're back with more Lienette. We're back with more. We're back for hearing number 4 today. Good morning, afternoon, evening, night, wherever, whatever, etc., etc. I'm just glad all of that stuff is happening right here on my channel. It's Monday. It's a Monday following a very, very long St. Patrick. I almost said Thanksgiving Day, St. Patrick's Day weekend. But we're here. We're I'd say about 92.7% recovered from the weekend, the long weekend. But just to drive me back into the depths of misery and headaches, it's time for hearing number 4 in the hearing involving Jeremy Hales and Lienette the Tortoise Queen. Hearing number 4 in a temporary restraining order hearing. Supposedly a hearing to decide whether or not to finalize it and make it a permanent restraining order. These things usually take an hour at most. We're into hearing number 4, multiple hours, most hearings. Are we all ready for this, to do this again? I know a lot of you, if not most of you, have seen this already multiple times. I'm walking into this one. I haven't seen it. I saw a little bit of hearing 5 with DUI guy and Megan on Friday, I believe it was. Memory's a little foggy. I think it was Friday. Yeah. Haven't seen any of hearing 4. And I've already got like a little headache starting like right here in my left temple. I can already start to feel it twitch, and it's kind of it's starting to radiate outwards. Like right now, I'm already getting a headache. We'll have to muddle through this as best we can. How are we doing, Chad? Good to see you all here. We're waiting for folks to come in. We got 336 people here right now. 139 likes. That's literally means 200 of you. Exactly 200 of you. Well, exactly 197 of you haven't done your job and smacked that like button. I know I haven't done anything to make you like the stream yet, but hey, we're going to. That's why you're here. You're waiting for the like. So just get it out of the way right now. I promise that you'll have something to like or your money back, and I will be the sole arbiter of deciding whether or not something was likable or not. So take our after you've hit the like button, after you've subscribed, if you haven't already done so, and you two people on the replay crew, if you're watching this on the replay crew and you haven't hit that subscribe button, or anybody, just please do. Cost you nothing, makes me feel good, makes you feel good, win-win all the way around. You don't even have to touch it again, unless I mention that if you are subscribed, just double check to make sure you're still subscribed, because YouTube just kind of randomly unsubscribes people for some reasons. And then take our like and subscribe poll. Today's like and subscribe poll is right over here for me in this corner of the other monitor. What has been the result of watching these trials on you? What impact have these trials had on your life? These hearings. Did I say trial? Yes, I said hearings. Good. What has been the result of these hearings? I wrote this very quickly and didn't proofread. All right. The impact that these hearings have had on you. Your choices today are higher blood pressure, shouting at random YouTube videos, loss of motor skills and speaking ability, and an irrational fear of tortoises. Those are your choices. Just take our ridiculous poll. It's just totally just to remind you to hit the like and subscribe buttons. And we'll check back in an hour and see what people have answered. But so far, the shouting at random YouTube videos is far in the lead. Okay, well, there we are. Alan Walsh says, Jeff, we can't find the proof of posting for your parcel, so I don't know what to do. I'll check again on my end. We'll see if we can't scare that puppy up. All right, folks. Hey, Reform Congress is just to head it off before it becomes a problem. The rumor that Legal Vices was giving away get out of jail cards for free today isn't true. Yeah, well, if I had get out of jail free cards, I would hoard them all for myself, and I would use them with impunity. That's what I'd be doing. I certainly wouldn't give get out of jail free cards. I would be using them to get myself out of jail. All right, we don't have much time to talk. I think that's good enough. We got 5, 6, 7 minutes. So we got another 100 people in here. So we're just going to jump straight into hearing number 4. We've got both dogs are here in the room today in case we unlock the pig dog cam at the $100 super chat mark. They're locked and loaded and ready to go. And we'll just read the super chats as they come up, if any come up. Oh God, let's go. Share the screen for this hearing. Ugh. There we are. And place myself. Hey, Megan, I sound so thrilled. This is one of our poll questions here. You lose motor skills and speaking ability because of this. That's one of the symptoms of watching these hearings. Yeah, I'm so thrilled because it's sort of like that. You wake up and you've done something wrong, and when you go to school or when you go to the bar, when you go somewhere, you're just gonna get an ass kicking. It's like, all right, I know I'm gonna get an ass kicking. Let's just go get it over with. We'll come out on the other side, okay, but let's just get what's coming to us. Let's just, get our ass kicked and move on. That's kind of how we're doing this. We're just approaching it. I'm gonna try not to rant again. I almost made it during hearing number 3. Well, during part 2 of hearing number 3. But we'll try. We'll try to make it a little less shouty. But dang, Lienette and Judge Grudge, they make it so difficult not to get shouty. All right, without further ado, let's wander into the machine of pain. Let's do it. Let's put me up there where I belong. Put me up where I belong, where eagles fly.
All right, good morning. I'm Craig DeThomasis. It is 10:02 a.m. January.
Got a map of Florida now. That's pretty cool. We've got a map of Florida down here. Perhaps that will be able to tell the judge, if he would like pinch and zoom a little bit, where all of the entrances to the Hales property is and how accessible they are.
February 23. This is the case style. This Preston and Hales cases 38.
There we go.
23 ER416. We're here on.
Oh, you
several
812. That was a good album.
Motions from both sides. Status conference last week. Court,
Okay, peeps, how's my volume? Do I need to boost the court a little more, or
the
how
limited
is it? Am
notice
I
of appearance
overpowering?
filed on behalf of the petitioner was to address matters related to changing the date currently scheduled for January 26th to reconvene and resolve this matter. And respondent, or on respondent's behalf, counsel advised in part, I believe, that they were seeking a continuance or potentially for different reasons, wholly different reasons, and other matters related to that. And the court directed that the parties by 5 p.m. on Friday, January 19th, file their respective motions.
Oh, that was the opposite of boosting the court volume, wasn't it?
This matter is noticed for hearing January 18. 1 hour is set aside.
All right, how's that? Does that sound a little bit more balanced?
It'll eat into the time. I'm still going to allow and provide both counsel, each party 30 minutes apiece to present their arguments, but I want to comment on.
Oh, wait, he's actually said that he's going to allow the parties to say their piece. He's allowed them to give their case, to make their arguments. He's actually going to do that. I have a sneaky suspicion it's not going to happen for a while, though.
Few matters.
Hey, Flux. Hey, Kaiser, what's up? Hey, everybody. Everybody's here. MLS, everybody, all the mods, all the regulars are here.
Continue evidentiary hearing, which is scheduled to be resolved and adjudicated today, was filed January 19th at 8:12 p.m. The respondent filed on 1/19 at 5:22 p.m. what's styled as motion for sanctions, including voluntary dismissal, attorney's fees, and costs and related relief.
Still court louder? All right.
The matters filed.
Still court louder. All right.
Filed in effect today, really yesterday, specifically filed on January 22, Monday at 6:59 p.m., which is effectively today. The cover communication to my judicial assistant states attached is the case law portion to go with the motion for sanctions filed on Friday.
MG Law, what's up, brother?
What's attached to it does not contain even one copy of a case at all. So it's not a case law portion. It's styled as a memorandum of law with no cases attached to it, but certainly some cited within it. But it is primarily an argument, and it's considered as such. And so we've got, it'll come up later, we'll certainly address non-compliance with the directive regarding timing of filing documents, late filing.
Oh, my Lord. I don't. Do we have to? Again, I've lost my motor skills. He is so aggravating, right? Right from the get-go, he just really gets you aggravated. And he starts to just go through things that don't need to be gone through at about 0.75 speed. And then he can't tell what something is happening. Shuffle papers. Oh my God, just get on with it, Judge.
Effectively this morning or 7 o'clock last night, filing additional argument. Counsel's got 30 minutes to present their case on both sides. The matter is this: January 26th scheduled. Counsel for the petitioner filed what's styled as a notice of limited appearance on January 17 for the purpose of addressing a motion to continue the January 26th hearing.
Okay, that was Silverman, right? Yeah.
And it's clear to the court, and it should be clear to the petitioner, that if the court doesn't grant that relief, she may be without this counsel to to represent her. And
Okay, so Silverman's whole purpose for being
respect the
here
counsel in
is
way
to
and
make a
file
motion
notice of
to
appearance
continue the
to address
hearing.
this issue we're going to address here today. That has been characterized in part, or part of the characterization in this argument, which in one part was called case law and really is not case law, and is styled as a memorandum, but really is wholly
what?
Extreme
Holy
argument,
diver.
quite frankly, that describes in part the filing of the limited notice of appearance and the late appearance of an attorney potentially on behalf of the petitioner, but accurately today here on her behalf to argue a motion to continue. The length of continuance will be addressed if it's to be continued.
Oh, that's interesting.
We've got language.
All right, so now this is interesting to me, and we'll have to see where it plays out, because it seems to be what he's saying is that not only is Silverman apparently appearing for the limited purpose, his only job for being there is to ask for this continuance. And why the hell a motion for a continuance takes an hour and 27 minutes to decide? Well, I mean, I know why, because judge. That's why it takes an hour to go, yeah, I read everything, and no. Or, yeah, I read everything, yes, see you later. But he's also saying it was a late filing. He filed his appearance notice late? Well, I imagine that he would have jumped Jeremy's shit if his lawyer had... Sorry, I've already started cursing 17 minutes in. He would have jumped Jeremy's stuff if Jeremy's lawyer would have filed a notice of appearance after the deadline. He sure as hell jumped his junk for... That sounds even worse. He certainly jumped on Jeremy's counsel for making a motion for continuance 25 hours before the hearing. All right, let's see how it goes. I'm not going to get overly upset just yet, but I have a sneaky suspicion it'll happen.
In this quote, memorandum of law, unquote, which is not really a memorandum of law, that states in relevant part as to this issue, calling counsel for the petitioner, who's really just trying to address the issue of calendaring, that it's a ridiculous excuse for an attorney who's coming into a case that's already scheduled for trial. Attorney Silverman is no exception to the principle that an attorney takes the case as he finds it. He should have declined representation if he couldn't fulfill his responsibility of being here on January 26th.
Well, okay, all right. Now he's faulting Jeremy's lawyer for making this motion, which he's just really saying it's not really a motion, it's an argument of law. But it seems like Jeremy's lawyer is saying exactly the same thing that the judge said to Jeremy's lawyer when he took over from Feather. He's saying exactly the same thing. Because remember, of course you all remember, the judge rode his ass for what, 25, 30 minutes or more about are you sure because your lawyer may not be prepared to do this, and if your lawyer didn't sit you down and tell you he's not up to speed and can't do this, it's unprofessional, there might be some ethical. He went on this forever, and now they're just doing the same thing that got done to them, and there you go. And the judge doesn't seem overly concerned about that. The judge doesn't see, well, hell, at least the other guy, he was there for 25 hours, whereas Silverman had, 2 weeks to prepare an argument on this case? I don't know what would possibly take 2 weeks.
He has no good cause.
Oh, yeah, I forgot to read these super chats. That's why the reason I stopped at primarily Paralegal Liz, who's been here for 7 months. Thank you, Paralegal Liz. Happy Monday, friends. Have a great day. It's my mom's birthday, too, so happy birthday to her. Liz, tell your mother happy birthday from me. Tell her I said hi, and hope she has a wonderful, wonderful happy birthday today. And been there, done that for the $5 super chat, breaking the super chat seal. Imagine Lienette was your mom, that poor kiddo. Well, especially since the kiddo's not really her mom and her real parents want her back. That makes it even worse. poor child indeed.
acting with contumacious disregard of the court authority, bad faith.
We learned the word
gross
contumacious
indifference
last
to an
week,
order
didn't
of
we?
the court, conduct that evinces deliberate callousness, intentional abject interference with the orderly progression of the case, and going further and further. And I point that out because I want it to be addressed by both counsel that the record actually shows that on November 29, when the respondent was represented by counsel Mark Feather, when offered an opportunity to reconvene the following morning at 9 a.m.
Oh my Lord. I am losing very, very quickly. I'm losing myself. I'm breaking my promise that I'm not gonna rant. Oh my God. Now, see, this was things like what Mark Feather did with 48 hours before. He was basically saying because of what she did, previous lead counsel is now a witness in this case. I just got this. And he said, I'm ready to go today if I have to, but I would really like the continuance. And the judge, as we just said, rode his ass for 20, 30 minutes or more about how that shouldn't happen. And all we're seeing turnabout is fair play. Whereas, hell, Silverman had a lot longer to prepare for the argument. He could have filed everything in a timely manner. They didn't need a continuance, but silly, stupid, naive Lorax me. I expected the judge to sort of rake Silverman over the coal. I know they're friends, but you still at least have to do something in court to show that you're not favoring one party or the other. So I expected him to kind of call Silverman over the coals here, just kind of rake him over the coals a little bit for doing the same thing. And I thought that's where he was going when he started talking. But now what we see is that he's doing exactly the opposite. He's going, well, they're objecting to all of this, but remember, I gave it to them too. I did it to them. And now they're coming back and they're arguing that opposing counsel is doing this. He's going to take this out on Jeremy's lawyer, isn't he? He's going to take out Silverman's failings, Silverman's bullshit. He's going to take that out on Jeremy's lawyer and say, well, you did the same thing and I was decent to you, so I got to be decent to them. That's what he's going to do, isn't it? Oh, my Lord. Oh, my Lord.
Representations to the court, which deemed his client.
Your intercoursing statements about misrepresentation to the court. There was no misrepresentation to the court about that. Judge, go back. You keep referring to the transcript and somehow you still keep getting wrong what actually happened when he was talking about the 15 minutes, when he's talking about how they need to get to Ohio tomorrow for a hearing relating to this matter in Ohio. There was a very slight miscommunication that is easily explainable by, okay, the hearing wasn't there, but the one-way ticket we have, or the ticket we have to get to Ohio is tomorrow morning. It was a tiny it wasn't a misrepresentation. It wasn't a lie. This judge, oh my God, I can't.
First of
there goes my damn promise not to rant. That lasted exactly what are we, 24 minutes into this minus say 5? We'll say it lasted less than 20 minutes. Great.
Misrepresented why the continuance is necessary. The court relied on the misrepresentation, granted the continuance.
Oh my God.
And then when the court scheduled it for the following week, and Mr. Feather represented no objection to that date, and the court said, this will be a priority. It's going next week. There was no pushback. There was no judge, but I might have something. And then he files, again, another filing after hours, basically the Monday before the Wednesday hearing, a motion to continue that does nothing to point out that something came up between agreeing to the court date and the actual court date, but instead, in relevant part as it relates to today, Mr. Shockett, who was co-counsel to Mr. Feather, files a notice of appearance 24 hours and 20 minutes prior to the commencement of the hearing that was scheduled to conclude these proceedings.
Oh
on
my
December
God.
6th. And so for counsel, this is concerning to the court, for counsel to describe the actions of an attorney who steps in with a limited notice, trying to address the limited issue of the calendaring of the event that's now scheduled for 26, which he's already told the court, I can't be here, but can you allow me to be heard?
Wait, didn't he have 2 weeks? I thought he had 2 weeks to prepare for this. Am I confused? I thought Silverman had like 2 weeks to prepare for this hearing, and now he wants the continuance. And I get the judge did exactly what I suspected he was doing once he started talking and got a few words out of his mouth. He is saying, how dare you do this to Silverman when you did this already once? Totally different circumstances, totally different situations, totally different reasons. Judge, shame on you.
As to that matter, we have an attorney calling that bad
Yeah,
faith, disregard, and
there is a petition down there to remove him, but yeah, that goes.
And nonetheless, we're dealing with current co-counsel of the respondent, who 24 hours and 20 minutes took on a case that he knew he could not be prepared for, and he filed another motion to continue, which would have been about the third motion to continue, if not the second, depending on how you look at it.
What?
On behalf of the respondent. And so I would just suggest you all evaluate the context in which we are brought here today and keep the extraneous, unnecessary name calling and characterization when the record evidence establishes.
But was it unwarranted and unnecessary characterizations, or was it accurate? Judge, come on, man. You can't be doing this. Stingy with the $2. God, multiverse legal vices is so frustrating. I'm the multiverse legal vices. Oh dear.
That the court accommodated current respondent's counsel when he needed a continuance because he said he couldn't be prepared, because he got into the case knowing the case was scheduled, and he came in as co-counsel to a lawyer that told this court on November 29, somewhere between 4:50 p.m. and 5 p.m., Judge, I only need about 15 more minutes.
Oh my Christ, he's going off on this. He's hitting all the buttons today. He's hitting the 25 hours and 20 minutes. He's hitting the you did this. He's hitting the scheduling date. He's hitting, oh my God, he's hitting every single one of these issues. The 15 minutes thing. What the hell does this have to do with anything, Judge? Nothing. Why is he even talking about this 15-minute shit again? It has absolutely zero relevance. And again, it's misrepresented.
Of my voice. I found that to be incredulous understatement of the morning. I don't know of a lawyer who could have, because he said he needed to present 2 additional witnesses. He needed to cross-examine the petitioner, who at that time took about 2 hours to not even get through with her direct testimony. And he didn't even address whether he was going to call his client and or maybe forgot whether he was going to make legal argument to the court. There was no way anyone, after this judge has spent 40 years almost on a daily basis in a courtroom, could have done that in 15 minutes. But
you know what? He didn't say he was going to do that in 15 minutes. Again, it's a misrepresentation of the record. It's a blatant misrepresentation of what was said. Judge, you need to go back there and read your own damn transcripts, or go back and watch the hearing, because that is not what happened. And continuing to say that is what happened does not make it so, and will not make it so. Again, Judge, you should be ashamed of yourself for this misrepresentation. And then to attack them for misrepresenting when that's all you've done is misrepresent what the Hales attorney said. This is infuriating.
That context, current counsel, co-counsel of Mr. Feather, Mr. Shockett, took the case and said he couldn't be ready because he only had 24 hours and 20 minutes. And this court again accommodated the respondent. I want you to keep that context in mind. The court's taking 12 minutes of your time. Mr. Silverman, it's your motion that's first up on the docket.
Oh well, okay. I'll give him the keys to the frickin' city if that's what he wants. I'll give him the gold medal. I'll give him the silver star for going over the entire damn record again in 12 minutes, which again is 12 minutes. It's going to be billed to Hales. 12 minutes, which did not need to be spent. In fact, this hearing could have been concluded in 12 minutes, not an hour and 27 minutes.
Yes, Your Honor. Well, firstly, that's what I want to address. The first thing I want to note is I saw Mr. Shockett reference in his email to the court on Friday, and the court just referenced it, a 5 p.m. deadline on Friday. I'll be candid. I don't recall I remember the court saying we had to file by Friday. I don't recall 5 p.m. If the court said it, I do apologize. I don't fault Mr. Shockett for filing after 5 p.m. The initial motion he filed. Obviously, I filed mine 7-something p.m., but both were filed on Friday. What I do object to is Mr. Shockett's motion being heard today. The reason I object to that is when Mr. Shockett filed that motion, forwarded to the court on Friday, he indicated there was additional authority, additional information he wanted to include. As the court noted, that was not filed with the court, styled as a memorandum of law until, I believe, 7 p.m., 6:55 p.m. Yesterday evening. So it was filed almost 2 hours after the close of business, the evening before a 10 a.m. hearing the following day. I don't engage in trial or hearing by ambush. I respectfully ask the court to decline to allow Mr. Hales and his counsel the opportunity to do the same.
Trial by ambush? Trial by ambush? You've had 2 weeks to prepare for this. There's no ambush going on here. How is this a trial by ambush? You've had nothing but time to prepare for this case. What the hell is going on here?
Candidly, I had a rather full calendar with my family last night. I did not have.
Oh, okay. Well, so you chose to prioritize you got to live with it, brother. You got to live with your choice. You could have been preparing for this case. You could have been preparing your arguments. You could have been getting ready, but you chose to spend it with your family. You made a choice. You had the time. That's one thing that I hate is when new paralegals or when new first year lawyers or whatnot come into the firm where I work and I didn't have time to do this motion. You're a lawyer. All you have is time. Your life is built on hourly charges. Your life is built on time. You have the time. Everybody on planet frickin' Earth has exactly the same amount of time every day. You prioritize. Sometimes you got to work all night. Sometimes you got to tell the family, I'm sorry, but I got something important to do. Sometimes you got to make those hard decisions so you can be prepared to go to court and represent your client. You chose to do otherwise. Now you want a freebie for it. I don't think that's how that works.
I've read what was filed last night. I've not had the opportunity to go through it in full and to pull all the cases and read everything. I therefore object to it being heard today. We can reserve for another day the arguments I have on the fact that the motion or whatever it is completely unfounded, fails to cite relevant law, and the law that I have been able to review thus far seems to indicate it doesn't support what they're asking for. But I am before the court on a limited basis, pursuant to the rules of family law and procedure, asking the court to continue this Friday's hearing. Contrary to the, as the court noted, rather bombastic assertions in the pleading filed yesterday evening, I have done what I think is the appropriate and ethical thing to do here, because when Ms. Preston contacted me, I knew I would not be available this Friday. I will not make a full plenary notice of appearance in the case if I know I'm unavailable for a trial or hearing date that's already set. That is why, pursuant to the family law rules of procedure, I have filed a limited notice of appearance, asking this court to consider continuation of Friday's hearing. As the court correctly noted, if the court denies the continuance, I will not be able to represent my client on Friday, and Ms. Preston is fully aware of that. The court denies the continuance today, I imagine the court will be getting from me a motion to withdraw, stipulated motion to withdraw before the end of the day. With that being said, the court has laid quite a bit of the record already. This case has been previously continued, I believe multiple times at the request of the respondent and or his counsel.
Let's misrepresent the record day here in court. I'm in bizarro world here. Other than the first motion, if I'm trying to think of something other than, well, hell, not even that. All of these are really because of her. All of the motions that Jeremy's lawyers have made for continuances were because of her or the things she did. She initiated these by doing dumb shit. So to say it was all at the request of, the defense, that's of the respondent. Sorry. While that may be technically true from a filing point, it's her that created the situations that caused the need to do this. I mean, literally every time I was thinking, well, maybe there was one, but then no, there's not. Every single one of these motions for a continuance were because of something she did. This is all on her.
I have not yet obtained the videos of the court proceedings, although I've had, I'd say pleasure, but I would say more displeasure of having reviewed at least some of what Mr. Hales has posted online. And there are excerpts of that court proceeding online, which I understand is the subject of another proceeding in this case next Monday. And I think that on an equitable basis, Your Honor, as I point out in the motion, both parties are entitled to representation by counsel. This court has previously continued this case at the request of Mr. Hales. So
because of your damn client.
I'm asking the court to do the same in this case so that my client's counsel, potential counsel, can be accommodated. This is obviously a complex case. There are issues related to the Fifth Amendment. I think I point that out in my motion to continue. Mr. Shockett raised it in an entirely different manner in the document he filed last night. Regardless, I am aware from the state attorney's office that there are criminal allegations against both of these parties.
Okay. All right. This does not need to be brought up. That absolutely has no bearing whatsoever on this case. There is no reason whatsoever to bring up any criminal allegations against anybody involved in this. It has nothing to do with whether or not to grant a continuance in this case. That is dirty. That is scummy. That is underhanded. That is absolutely unnecessary. And why Jeremy's lawyer isn't going through the roof, I don't get it. That would piss me off.
So the stakes are somewhat higher than they might be in another civil case of similar character. And so for the reasons I cited in the motion, Your Honor, it is very important that my client be represented by counsel. The case law that I do cite in my motion clearly stands for the proposition that continuances should be granted when reasonable and when not overly prejudicial to accommodate a litigant's request to obtain counsel in the context of injunction proceedings. And that is precisely what we are asking the court to do this morning. It is not, although this is a somewhat complex case.
It is not
really complex, and so otherwise.
In what way is this case complex? This is the simplest case in the universe. You look at it, you go, okay, prove that these bad things are affecting you. Prove he did this. You can't prove him. Okay, it's denied. Oh, by the way, you were supposed to have signed this. Did you sign it? No. Okay, it's dismissed. You failed to meet the legal requirements to have this given. This is very simple. That's why this is unheard of that it would take this long. This is absolutely the opposite of a complex case.
Going to stand by what's in the motion, and I think it clearly sets forth a reasonable and quite frankly compelling case for a reasonable continuance of Friday's hearing.
Thank you, counsel. Let me just ask you before I turn to respondents' counsel with regards to the length of continuance. Obviously, the court has to weigh any potential prejudice to the respondent who has currently a temporary injunction in place that has been modified effectively on 2 occasions by this court in conformity with the Second District Court of Appeals opinion. That's the most recent modification, issued 12/29. This court, in conformity with that, modified it to his benefit to some extent. But obviously the court needs to weigh the length of the continuance in light of the totality of the circumstances, which I'll discuss at a relevant point here this morning. And so give me a sense, for instance, you know, the case can be continued to the following week. It could be 2 weeks. Give me a sense of what you think you need to be ready and prepared. What really becomes, just in short, day one was continued, and despite offering to reconvene the following morning, November 29th to November 30th, and the respondent, as I mentioned before, asked for longer time. When we reconvened early January, there was a bomb threat in the middle of the hearing, and thus we did not complete that day's events, and so we're scheduled for the 26th.
Oh, so he acknowledges it's a bomb threat. It was a bomb threat there, and we somehow, again, somehow this bomb threat was Hales' fault, because everything has been Hales' fault, right? Everything has been respondent's fault. Every time this has been delayed has been because of them, except for the bomb threat, right, Judge? And you mean except because Lienette made respondent's lawyer a witness in this case? You don't. There was that exception too, huh, Judge? Yeah. Sorry, I broke my promise not to rant. We're 42 minutes into this, and I think I've already ranted about 8 times.
So, in effect, it's
we're never going to get done.
Of the continuation. And I understand that you want to obtain copies of the court proceedings. So, just give me a sense what you think the time frame.
Oh my God! Talk faster.
Obtaining copies of the court proceedings is not like Mr. Lanier, my paralegal, has already started working on that. I don't anticipate I'll have any difficulty with that. I don't think any of the other business directed to Mr. Feather applies to me or my office, so we shouldn't have any. I should have those in the next couple of days. I do intend to depose Mr. Hales, and I believe that can be accomplished in short order, probably within the next 10 days. When we get to the appropriate part about any motions to bring with respect to discovery, which again, respectfully, I don't believe properly before the court today. I believe that Mr. Hales, through counsel, if he can properly serve Mr. Cook with a subpoena, has the right to depose Mr. Cook. So I know he intends to take that deposition. As to a further deposition of my client, again, when we get to the appropriate date and time to hear that motion and the memorandum or whatever it is that Mr. Shockett filed last night, we could have a long discussion about the fact that it has improperly included communications between his office and mine in violation of the Florida Bar Rules of Professional Conduct. We can talk about the fact that he left out the fact that I have made a motion for 12.310D to terminate or limit my client's deposition. We can talk about the fact that it was improperly noticed.
You're not here to talk about that. You are here for the limited purpose of asking for a continuance. What are you talking about this shit for? This has nothing to do with whether or not this should be continued. Shut up. Get a full appointment or don't. Talk about the extension or don't.
It was taken as a video deposition when not properly noticed as such, and then Mr. Hales pasted the video of the deposition all over YouTube.
So
get to all that. I don't expect that he's going to be permitted to depose my client any further, but he does have an opportunity, if he can serve Mr. Cook properly, to take Mr. Cook's deposition. So I figure
Judge, none of this is relevant to the motion to continue. But
well, and so
Because I'm asking him what needs to be accomplished.
what he's saying, what's not going to be accomplished.
So,
he's arguing.
Right. Absolutely correct, counsel. Well, I'm asking him what. No, you're not. You're asking him what needs to be done. He's telling you what's not going to be done.
we have 2 depositions that need to be taken. I believe we can get that accomplished in the better part of a day, if not an afternoon or a morning. So I would think at this point, a 2 to 3 week continuance would be appropriate.
Okay.
So that's where I am.
I just want to get a sense. We'll narrow down. request. Mr. Shockett, let's first address the issue of why or
Let's
why
go,
not
Shockett.
should we address what was characterized late last night after hours as
Oh my God, you petty son of a bitch. You could have just said what you filed, but no, what was characterized yesterday after hours. Judge, that's just being a petty son of a bitch. Absolutely uncalled for. And clearly displaying your bias. You haven't really mentioned much about what they did wrong with that. Well, okay, you haven't mentioned anything what they've done wrong with, and I'm pointing to Lienette over here. He hasn't mentioned anything that Lienette and her counsel have done wrong, but he's got to make this stupid petty statement.
Further, but he does have an opportunity, if he can serve Mr. Cook properly, to take Mr. Cook's deposition. So I figure we
Judge,
probably-
none of this is relevant to the motion to continue, but
Well, and so
because I'm asking him what needs to be accomplished.
what he's saying, what's not going to be accomplished.
So
He's arguing.
we have two depositions that need to be taken. I believe we can get that.
I forgot that if I push the back arrow button on this video, it goes back 1 minute,
So I would
not
think
5
at this point,
seconds.
a 2 to 3
Sorry.
week continuance would be appropriate.
Okay.
So that's where I am.
I just want
Listen to this petty
we'll
shit
narrow
again.
down that request. Mr. Shockett, let's first address the issue of why or why not should we address what was characterized late last night after hours.
Late
as
last night after hours. Absolutely
case law.
unnecessary to
It's
say.
not case law, it's titled memorandum of law, but really is an argument. But certainly you could make argument, we're here for argument on issues. But with regards to the laundry list of sanctions that you're seeking, there's an objection to hearing that today.
Sure. Thanks, Your Honor. Good morning. I'm going to answer the continuance issue by giving a little history first. Obviously, let's start from the beginning. They already have effectively gotten a continuance. Your Honor recalls, she didn't appear for her. We were supposed to finish on January 4th.
Yep.
She was supposed to appear for her deposition December 21st. So was Mr. Cook. They didn't show up. They filed motions. She filed a motion to reschedule her deposition. She also filed a motion to not take Mr. Cook's deposition. The day of the bomb scare, Your Honor ruled that both of those depositions need to go forward. And we scheduled them here in open court on the 16th and the 17th. On the 16th, this is what's shown here. We'll address the issue, whether this is ready for today, but you know what happened, Judge. They didn't finish the deposition. And we're complaining about the actions of opposing counsel before the notice of appearance. I don't know of any rule that says you have privilege to say something to somebody in an email and you can't be shown to the court. That doesn't make any sense. So what you have here is we gave you a Facebook post and we also showed you some emails where before in their appearance.
You're arguing the merits of the motion.
Okay, well, I just wanted to point out that with that,
Procedurally
effectively they got a continuance because we didn't get our required discovery.
Well, the record reflects that the respondent got a continuance in November 29.
Absolutely.
It was the first continuance based on misrepresentations to the court. And
Oh, you son of a
benefit
bitch.
of that, to the significant high potential for detriment to the petitioner. Detriment not only because it's still hanging out there, but at that time it was hanging out there without a temporary injunction in place. And the court precedent and whole specter of weighing continuance with the temporary injunction is wholly different than one when there's not. When we came back, when you were appearing on the respondent's behalf, right at the outset, I said to you, well, now the court has to look at this differently because intervening, there was a second, I believe, if not third, but second, I believe, supplemental petition, which resulted in a temporary injunction. And despite representations to the contrary, so that Mr. Hales is aware, when the court receives a petition or a supplemental petition as a matter of law, this court must accept what's alleged in the petition as true. Period. End of discussion. The hearings decide if it's true and if it's competent substantial evidence. But the court must accept it as true. So despite allegations that the court is accepting what she says, yeah, as a matter of law, when it's pled in a petition or a supplemental petition, why? Because the court must do so.
Yes, the court must do so. But as you said, you must hold the hearings on this. This hearing should have been 15 days later. Okay, so they got one continuance, and then another and another and another, and because of her, not because of him. The first day she ghosted the court on that deposition, the judge absolutely should have removed that temporary restraining order. It should have been done away with. It should have been dismissed outright because she ghosted her deposition with no reason or pre-notice whatsoever. So again, judge blaming everything on that first continuance is absolutely horseshit.
That's plain and simple. There's no choice in that. When we get to hearing, the court can reject or accept any or all testimony of any witness.
Okay, that's a great point. I want to just touch on that.
Hang on.
Yeah.
That's the second motion to continue that you are.
Oh my God, he's going to go through every one of these?
Respondent's third motion to continue. So that was on 12/1 at 5:56 p.m. The respondent's second motion to continue. Respondent's third motion to continue was 12/5 at 12:53. Respondent's fourth motion to continue was the January 4th proceeding.
Well, that was in conjunction with a motion for discovery violations of not showing up for depositions.
I hear you. I know why. I've got institutional knowledge of why, but
Every case, every lawyer, I took the case just like Mr.
Yeah, see, again, God, this is making me so angry. He's saying, yeah, your client applied for this continuance. It's your client's fault. Your client wanted the continuance. And then he tries to explain the reason we did it was because we didn't get the discovery because she didn't do the deposition. She just ghosted us. He's like, well, I know all that. I have the institutional knowledge. You don't need to go over that, but you made the motion. I mean, what the hell? Where is the reason in this? Where is the objectivity in this? Where is holding her to account for her failings and the failings of her counsel? Judge, this is the worst yet. This is the absolute worst. I'm glad I used the thumbnail I used today with the evil comic book judge, because that is what he's become. He's become the evil comic book judge. Judge Grudge, the comic book villain is where he's at now. It's still Jeremy's. Yeah, exactly. It's still Jeremy's fault because they made the motion. What? I mean, this
We take the case
so ridiculous. Oh, we need a palate cleanser. Definitely need a palate. We already got the multiverse me. We need another palate cleanser quickly. David E. Jones says Silverman was only there to file a continuance. Yeah, but he's still arguing what he's not going to do and what's not going to. He's still kind of arguing it, which again I ranted about there because clearly he shouldn't have been talking about those things. And Charlie Lynn, hey Charlie Lynn, what's up? Became the newest member of the Clean and Sober crew. Thank you so much for joining the Clean and Sober crew. Puts a smile on my face. I hope you'll be here for a bit. Stick around, come back often, and I promise there won't be so many rants once we get done with this stuff. The Chuggy Show Live. Thank you so much. Turtles people too. La la la. Boxers and snappers and giants too. Deserve to live free because turtles are people too. I record this for you. Lol. Okay. All right. Nick Starro, judge. Yeah, okay. Yeah. If I file my motion to off you fuck, this applies to tortoise stripper Silverberry and Your Honor. Yeah, that's just off you fuck. That's my little catchphrase. My little get myself demonetized. It's only 53 minutes in catchphrase. Thanks, Nick. And MS Crim. She's a pro se litigant. Plus, she loves former stripes. She loves former stripes. Well, she's not pro se here. She's got two lawyers with her today. Soon after this, I understand she's pro se. Is she pro se again? No, I'm not sure if she is right now or not. I got to watch that fifth hearing again. My brain was wandering there. I was tired when I watched it over with Megan and DUI guy, but we'll have to see how that turns out and continue with other things. Oh, thank you ever so much for that palate cleanser, everybody. Let's dive right back into the nightmare.
I got short notice and I said, I'm going to ask, I'm not prepared, and I appreciated Your Honor doing that. But this, I'm just pointing out here that this is a continuance. This has to happen.
What I did as a matter of law was to provide due process to Mr. Hales, your client. I wasn't going to deny him that.
Okay.
And so my question is, why are we suggesting Ms. Preston ought to be denied counsel?
I'm not. I'm saying the opposite. Effectively, they gotten it already. By her deposition not continuing, the Nettles case, Judge, we have to have discovery, and it didn't finish. Mr.
All right,
Cook,
let's put it in this context.
Okay.
Everything about context. Your co-counsel, current co-counsels, to this day, Mr. Feather represented he could complete the case in 15 minutes. In hindsight, in error, this court regretfully allowed the deposition of Ms. Preston to take place in the first place. You're effectively taking a deposition of a litigant who in the middle of her direct testimony is stopped. We want to now take her deposition. I regret approving that. It's my understanding from representations of counsel, and we've got a record potentially of what, but it seems to me that process.
Oh, you didn't miss a rant at all. There was no rant missed. It was just me ranting about the 15 minutes again. And how he's pointing. Yeah, I was just ranting. He's like pointing, which is inappropriate. I don't even know why I hit the mute button. Oh yeah, I hit the mute button because I had to sniff really loud. I forgot. Sorry about that. Yeah, just him pointing his finger is very inappropriate. He's the one that's getting angry now. And of course, when you're angry, you take it out on the guy you don't like, which is what he's doing with the Hales side of this. It's really I was going to say disgusting or despicable, but it's another D word. It's disappointing. It's disappointing to see a judge do this.
Which has resulted in, we'll fill in the blank, number of hours of deposition, which you're now saying was unsuccessfully left incomplete, has now, I just heard from Mr. Silverman, also been published to the internet, in addition to your co-counsel, in violation of the Supreme Court administrative order, SCAO 11-222, and in violation of AOSC 11-22, and in violation of our Chief Judge's administrative order 1.14 version 2. Despite that, he requested and obtained unredacted copies of the 1129 and 12-6 proceedings, and is now answering to contempt charges from the Chief Judge, since it's his administrative order, about what then ends up being disseminated and published on your client's YouTube channel. Understood. And so that's another consequence of there being additional time. And now I'm hearing this morning that a deposition has been provided on YouTube. And let me just ask the question, is it a video depo?
Well,
it is a video depo.
It was improperly noticed as a video depo. It does not comply with the rule.
Well, let's follow the rules. That's why I'm asking the question, because there's a rule right on point, 1.31.
There's a rule that you're only supposed to be able to talk about whether or not to grant a continuance here, Silverman. So why don't we follow the rules and you just shut the fuck up and sit down talking about this? This is beyond the scope of your appointment.
0.
There is. And so the notice that was filed on January 15th, I believe it was, in the title, just the title says notice of taking video deposition by subpoena Deuces Tico. Putting it in the title does not comply with the rule. You can put things in the title.
I've got the rule right here. Let's go to the family rule. 12.310 subsection B4. Any depo may be recorded by video without leave of court or by stipulation, provided you follow the following rules. A, notice must state in the notice it's to be video with the name and address of the operator. B, the court reporter must be stenographically recorded by a certified court reporter unless otherwise agreed. C, procedure must on camera identify the style, state the date, swear in the witness. D, custody of the tape and copies. The attorney requesting must take custody and be responsible for safeguarding the video.
If I could jump in right there. I did yesterday reach out to Mr. Shockett's office and ask him to provide me with a copy of the videotape or the video recording. I guess nothing's on tape these days. He
Yeah, I was
directed me
gonna
to the
say
court
that.
reporter indicating that they had custody of that and that I would have to obtain it from them. We had a spirited discussion about the cost of obtaining that. But the notice, although it states notice of video deposition with subpoena ducis tecum, I would note there's no subpoena issued to a party, and there hasn't been a subpoena issued to a party in this case, does not contain the information about the videographer. It simply says the deposition will be taken before a court reporter and gives the name of the court reporter and
There was no videographer. It was Zoom, you fucking idiot. It was a recorded Zoom call. There was no videographer. This is the problem with these damn rules when you want to live by the black letter of the rules. They're out of date. They're out of touch. This rule was probably developed in like the 70s or the 80s, maybe updated a few times, but there was no videographer. It was a recorded Zoom call. And Jeremy, your lawyer needs to stand up immediately and say, Judge, tell him to shut up. He is well beyond the scope of his appointment in arguing what is happening here. He's only supposed to be arguing for a continuance. All of this about whether or not a deposition that's already been taken followed the rules or not is not what he is representing here. He has not been hired to do that. That is beyond the scope of his representation, and Jeremy's lawyer needs to jump up and tell him to shut the hell up.
internet address for the court reporter, and that's it. And regardless of that, if their position is that the deposition wasn't concluded, my understanding is firstly that my client indicated she wanted to read the deposition. She was never provided that opportunity. And just yesterday, Mr. Hales, in one of his many monetized YouTube videos, plastered that video deposition all over YouTube to his 600, 700,000 subscribers, which is highly problematic.
Why?
So, Mr.
Why is it
Shaw,
highly
while we're talking
problematic?
about your need to redepose an individual who midstream.
Wait, why is it highly problematic that the deposition was put online? Why? It's not secret. It's evidence in a case. Why is this problematic? Yes, he did. All over YouTube. Yeah, posted all over YouTube to one channel that people can choose to watch or not watch. He went up plastering. Someone give me a reason why this is problematic.
Trial, who your co-counsel only needed 15 minutes to call.
Oh, shut the fuck up. I am so goddamn sick and tired of hearing that 15-minute bullshit, Judge. You got to knock that shit off. I am really fucking tired of that. And great. Goodbye monetization for this video. I can't wait 2 hours to start cursing. This guy's an absolute dipshit. Seriously, so the next time he mentions this 15-minute shit, come on, something's got to be done. That is absolutely ridiculous.
His own client argue the case and cross-examine. So that would leave, I'll be generous, leave maybe 10 of those 15 minutes to cross-examine. Has now taken several hours of deposition. You have as his co-counsel. It's not complete. It's now broadcast. Do you agree that it's been broadcast on your client's YouTube channel?
I think I've seen a portion of it, yes.
Okay. Well, let's talk about then whether the deposition in video format was in conformity with 12310B4.
It's not an issue today, Judge. Whether or not it's in conformity has nothing to do with what's going on in the court today, and it is beyond the scope of his representation. Again, he is only retained by his client to ask you for a continuance. This has less than nothing to do with the continuance. He shouldn't be talking about it, and you shouldn't be addressing it. This is utterly improper.
You've safeguarded the videotape, and clearly the language of video.
I'm not.
Format
look,
otherwise recorded in.
There's a little bit of performance that goes on in people's YouTube channels, but I am genuinely pissed off right now. I am genuinely enraged here. This is absolutely beyond the pale. Yellow Flash, what's up, brother? Just comes in with a lol. Thanks for breaking the tension there, Flash. Love you, brother. No, this is utterly incomprehensible how this is allowed to go on. Yeah, it is infuriating, MG. And again, I don't want to be ranty guy. I want to sit back. I want to have fun. I want to joke and laugh at these things. I want to experience it. I want to follow the court trials. I want to read the motions, see the evidence. But this judge is just sending me over the freaking edge. He's got me off the chain, as Lienette would say. It's utterly beyond the pale. I know I've said that already, but it literally is just, it's despicable. Now I'll go back and say it's despicable and disgusting. There's absolutely none of this should be happening. Like I said at the beginning, this whole thing should have been a 15-minute hearing. Do you need an extension? Well, we don't think he deserves an extension because it's his fault. The judge says, all right, I've considered both of your motions and both I've heard both of your reasons. Here's my decision. Now get the fuck out of my courtroom so I can bring on the next case. Lynn, thank you for gifting 10 Legal Vices memberships. Thank you so very, very much. I appreciate that greatly. If you were one of the people that got one of the 10 gifted memberships, make sure you give Lynn a super special thanks. Thank you. And the Japanese Yakuza 1 with the 200 sexy monies, thank you so much, just got here, and this sounds fun. It doesn't. It's not fun. This is my profession. This is my career. This is my calling in life, being treated this way by a butthurt judge with a grudge against a guy who is just wanting to be left the fuck alone. I wish it was fun. Rocco Rockwell, member for 15 months. Thank you so much for being one of the OGs. Is there anyone or anything that holds account or oversight on judges like this? The Supreme Court, the Bar Association, people like that do. Well, there's a motion now that's being heard to get rid of him, to get the judge off the case. There's a whole procedure that's going on that unfortunately is going to take a very long time probably to determine whether or not the judge should be removed from this case. But I mean, this is gross. And I think I think we're there. I think with the 10, there we go again. Now is the time to do this here. With the 10 super chats, that gives us what the $50, which added to whatever's come in. I think we've got to that point in the proceedings where we all need our therapy dogs. I think we need the therapy dogs. Let me where's the therapy dogs? Bring on the therapy dogs. I need to set up the therapy dogs real quick here. All right, there's we've gotten there, folks.
Release the hounds.
There we go. Got Strawberry and Yoda here. Our therapy dogs have arrived. Give them cuddles, give them loves, give them all your attention. let the healing energy of Yoda and Strawberry flow through you. Let me back this up a bit so that we can see them in their full glory. Right. There we go. Strawberry and Yoda. There we go. We need to just adjust it a little bit more, zoom it out a little bit more. There we go. Don't we all feel better already? We've got our therapy dogs here. See how they are all calm? Do that. be like Strawberry and Yoda. Just be all zen. Chaos coordinator, what? Jeff, does your neighbors called police on you for yelling yet? Nah, probably just blends in with all the yelling that husbands and wives do at each other around here. Oh my God. Oh, thank you, people. We've got our therapy dog here. All right, let's be like Yoda and Strawberry. We need to be more like them. And as long as we're stopped and as long as I'm stuttering and stumbling over myself, let's look at our like and subscribe poll. We've currently got 1,100 people here and 637 likes. 500 of you in the next 30 seconds, next minute while I do this, 500 of you need to go down there and hit that like button. It like takes that long and it costs you nothing. It's just free, gives you warm fuzzies, gives me warm fuzzies, makes the dogs happy. And while you're down there, click that subscribe button if you haven't already done so, and then take our like and subscribe poll. Like and subscribe, then vote. Here's the deal. Here's what we asked today. What's been the result of watching these hearings? What effect have these hearings had on your life? High blood pressure. 29% of you have said high blood pressure. I might be there. 39% say shouting at random YouTube videos. I'm definitely there. And 10% of you said loss of motor skills and speaking. Clearly, that's affecting me as well. And 21% an irrational fear of tortoises. So currently leading the pack is shouting at random YouTube videos. That's our like and subscribe poll. Get down there, smash the hell out of the like button, and subscribe if you haven't already done so. And let's continue our growth. We're on a steady march towards that $100,000 big, super awesome play button, which is going to go back here on the wall somewhere if and when it comes. Right. Valhalla waits. Brother, what's up? If you're not pooping in a grain bottle, are you really even trying? In a gain bottle. Let's not even talk about her beautiful outdoor toilet facilities and her beautiful outdoor shower facilities. I've got enough going through my brain. I don't need that there. Lancelot 652. Thank you, Val. Isn't it just a deposition? Isn't it just a deposition unless there's a motion to hide it? What is the big deal? There's no big deal. There's literally no big deal. I don't know why it's a deal. I don't know why it's a deal. But it's a deal to the judge, and he's the one that matters until the appellate court says he doesn't. So that's what we've got to go with. What do you think, Yoda? Yoda's just dead. To be like Yoda, just sleep. All right, folks, we need to get through the next 45 minutes of this. It's taking us an hour and 12 minutes to get through 30 minutes of video. I apologize. The day I said I wasn't going to rant, I've been like the rantiest ever. So I apologize.
Inclusive of that.
Well, my client, I gave it to my client, obviously. Sorry, you turn this on.
Okay, so the rule as I read it, correct me if I'm wrong, the attorney for the party must take custody and must safeguard it. So sharing it with your client, obviously you need to do that to get him prepared to proceed. Not a problem there. What did you do to safeguard, to assure that your client, who testified or has made it clear to this court that his I don't know if it's his main source of income.
Hey, we got a recovery addict raid. Everybody, recovery addict, thank you so much, brothers. Deeply, deeply appreciate it. Thanks so much for sending your people our way. And you recovery addicts, folks that are popping on in, make sure you hit that like button on your way in. Apologies in advance. The cursey words are flowing today. Cursey words are kind of a normal part of the show, but they're flowing a little extra hard today because this is really aggravating. But thank you so much for joining us. Thank you so much for the redirect over here. Recovery addict, thank you so much. Now, judge. He's gonna say, how is it safeguarding? How did you safeguard it? You clearly didn't safeguard it because he posted it. I'll just tell you right now, that's not what safeguarding it means.
But his source of income is monetizing YouTube videos. That's what's contained in the underlying this entire case, and you hand it to him. And are you on notice that your co-counsel has already, in violation of the Supreme Court order on no prohibition against dissemination, and in violation of our chief judge's Eighth Circuit order, prohibition against dissemination, despite attesting to that fact, your client has now monetized the posting of unredacted court proceedings from 11/29 and 12/6, resulting in a lot of collateral problems directly caused by that. So you know that your client has previously disclosed unredacted videos. You know that your co-counsel is answering to the chief judge in contempt proceeding. It would have been concluded yesterday, but your co-counsel was afforded another continuance because he's somewhere and unable to appear in court.
He's in the hospital, you twat.
Another side note of accommodation.
See, the side note of accommodation in a case that he's not even presiding over. This judge is out of control. He is now officially, he was a dick before. Now he is officially out of control. This is just an angry judge who doesn't like the respondent or the respondent's counsel, who happens to be a very good friend of the nutty petitioner's lawyer. And he's just going off. He's letting his emotions get the most of him, kind of like I've been doing the last hour and 20 minutes. But the judge should not be doing this at all.
But that being said, in that context and in context of this rule of safeguarding the attorney's responsibility, you provide it to your client, and now you know that it's posted on YouTube.
And I'll have a discussion. I will have a discussion. And
what steps have you taken to safeguard and to limit the...
Whoa! Does the rule say safeguard and limit the dissemination, or does it say safeguard? What does safeguard mean, Judge? Does it mean don't allow it to be destroyed, protect it from being destroyed? Is that what I think that's what the same safeguard means. I'm not sure if there's any particular case law or decisions in Florida, but that would seem to be the reasonable one to me. But I don't remember there being anything in there about and limiting the dissemination of the contents of the deposition. Don't go making shit up, Judge.
Continued publication of the 11/29 and 12/6 unredacted recordings, audio and video of this court.
I can't get an attorney-client privilege. But
you don't have to answer that. Did you tell me? Have you done anything?
I have discussions, yes.
Has it been unsuccessful?
And with Mr. Feather, although he's in the Philippines, I've had discussions about it. And
will you agree that it's been unsuccessful to date?
I would agree.
Here's the relevance of that question.
I would agree.
The relevance is I have to consider that when you say I want to continue to depose her.
Understood, Judge. If the court so pleases, either way, but I understand your ruling. If you want to overturn the ruling allowing your deposition, that's, if the court so pleases, that's your prerogative. I felt we need to
it's
take
not my prerogative. It's my discretion because it's granted to the court
right
under 1310, which is 12130 subsection 2D. The court at any time on motion of party, deponent, or upon showing that the exam is being conducted in bad faith or in such a manner as to unreasonably annoy, embarrass, or oppress the deponent. How about setting a depo that doesn't comport with and comply with 12.310B4, making it a video depo when it's not in compliance with the video depo rule, and then having it published on the internet in a case of cyberstalking that's now gone on since September? How is that not the consequences of now disclosing that video on YouTube, internet, bad faith, or in a manner that might be considered unreasonably annoying or unreasonably...
You're unreasonably annoying and embarrassing as for a judge. You're unreasonably annoying and embarrassing.
You take the depo. I'm asking you, why should I allow it to be continued?
Well, that's a different question because of what happened in the deposition, Judge.
All right, so let's start with, do you agree or disagree that the notice of the deposition...
Let's pause this to answer a friendly question. Crunchy Frog 0001. This is my first time watching court with you. Oh, I'm sorry. This is a really bad day to watch this for the first time. This judge really triggered me. I am incredibly agitated and angry at the judge, and cursey words are flowing. This probably isn't the best one to give you the the best impression of me, but I hope you'll forgive me and continue to watch. Is that a boxer dog tushy I see in the bottom left? No, these are both wait, let's get you out of here. Thank you so much for that, by the way. No, these are my two English bulldogs. They're both English bulldogs here. Let's do this. Then we can flip them around and we can embiggen them there. Yeah, that's Yoda is the white one and Strawberry's the brown one. They're brother and sister, and Yoda's dumber than a bucket of rocks, and Strawberry just won't stop moving. So that's my doggos. All right, let's put them back where they belong, flip this around, get back into the court. This is so frustrating. This really, really is. Stingy with the $2 super chat. Thank you so much, brother. 31825. Vice Squad. Today is Hales Part 10. Oh, this judge is so infuriating. All right, let me just do this here first. This crap is, says Megan Hunter, RRT with the $5. This crap is making my blood pressure spike so much the vein in my forehead is popping out. I said, like, when I started to get this little temple, thumping going on here, pulsing in the temple. It's all right. Sometimes these kinds of cases are funny and they're witty, and you get to make fun of one of the parties because one of the parties are complete doofuses and off the hook, like crazy or nutty, or do things that make it entertaining or infuriating. But sometimes you'll get a rogue judge that will do something utterly ridiculous and contemptuous. Sometimes you'll get a lawyer that'll make the profession look bad. But this case is an extraordinarily rare example of one party being, fruitier than a box of something that's fruit, like Fruit Loops, nuttier than a box of grape nuts. You have a client, you have a party who is absurd and over the top caricature of herself, and you have a rogue judge, all in the same, which really intensifies the stupidity of this. And then when you get the fact that judge just doesn't like the other side and happens to be really super good friends with the guy representing the nutty one, you're just off in crazy la la land with this case. And that's why this is, and people are like, what's so interesting about this case? It's not her. If it was just her, this would be a funny case to talk about the crazy former stripper who now runs a semi-fake tortoise preserve, which is basically some old starving turtles with moss and trees growing on their backs, living in two small galvanized tubs in the middle of a junkyard. This would be a funny case. This would be a funny thing. But we have a judge who is just completely off the rails, who's completely biased, who clearly is angry at one side and not the other, who is on the verge of making a mockery of the process. That's why this case is interesting, and I think it's very important. So you can expose judges that behave like this. Small town judge thinking he's the big giant swinging dick in the valley. Island has been a member for 6 months. If you're feeling extra frustrated, it can help to ask, did anyone tie you to the mast and leave you to the angry sea? No, then it could be a lot worse. I wish that would happen to me today. Duncan, Idaho, shouting in all caps, it's called the First Amendment and unsealed court documents, Your Honor, /genius. I cannot call this guy Your Honor. I'm so glad I'm not one of the attorneys of record there that are participating in the court hearings and have to call him Your Honor. I could not do it. And Duncan, Idaho, again with the $2. Judge is the epitome of actually. Ugh. Nick Starro, I can say fractwat on my streams because YouTube thinks I say Lord Farquaad. Okay. All right. So there we go. We cleansed our palate. We explained the dogs, and I've given my apologies to anyone who is just joining for the first time. I apologize. I'm a better person than this. I don't swear this much in real life. It just happens here.
Position that was taken by video as opposed to just audio was proper or improper?
It was technically in compliance. It said video deposition. The court reporter's name was listed on there. I guess hyper-technically, it didn't say videographer instead of court reporter, but it clearly said notice of video deposition.
There's no videographer, Judge. You recorded a Zoom call.
It gave the address. The only thing it didn't say was stenographer or videographer. It just said court
So
reporter.
the hyper-technical requirements of 12.310, as you put it before, have not been complied with.
That's correct.
So the notice was inadequate. The result of that is that you got video footage for your client to publish and to make money on.
I didn't do it for that reason. I did it here to show you exactly. We have it queued up here to show you what
Oh, now
happened.
you want to disseminate it in court? A
want to
portion
play-
of the
Oh,
video?
Judge, you condescending prick. No, so now you want to disseminate it in court? You know what? That's what you do with depositions, you dickhead. You publish them into the court record. You watch them. You call her as a witness and you use her deposition to impeach her. Oh my Lord. Look. Oh, and this is exactly what I was going to say. MG Law's reading my damn mind. I was say, look, bottom line, she went ahead with the deposition. That's the bottom line. She went ahead with this. You can't come back days or weeks later and go, oh, it wasn't done properly. You make the objections beforehand. You object to service. You object to the impropriety of the notice, the deficiencies in the notice. You make your objections to the form or whatever before it happens. If you go ahead with it, you waive these things. MG Law, the mind reader. Those defects are waived because they didn't complain about him. You lose. You must object in a timely manner, and that is before you actually sit down. You can't sit down and go, oh, well, we didn't really agree to do this because it was deficient. Plus, it's not his position to argue it because he is appointed for the limited purpose of asking for a continuance. And the judge shouldn't be talking about it because it doesn't have a freaking thing to do with whether or not to grant a continuance in this case. This is all absolutely improper. None of this should be happening. And the judge he's just up there giving his big lecture. Oh, so now you want to publish it in court. Judge, if you're going to give the damn extension, give the damn extension. What in the hell are they going to talk about for the next hour? God, I'm sorry. We're going to subject you to another day of this.
I would like to play for you. Yes, Judge.
You're all right. Have just going in my head about 7 or 8 different objections.
Well, excuse me. We also called during the deposition, if you recall, Judge, and there was problems right from the beginning of this deposition. 7 hours. If there were 3 hours of questioning, I'd be amazed.
Okay, so let's say at least 3 hours were fruitful, despite the fact that your co-counsel needed 15 minutes to conclude.
May I address
Oh,
that, Judge?
fuck off, Judge. Seriously. I am so goddamn sick and tired of hearing this 15-minute bullshit. Judge, honest to God, just you should literally be ashamed of yourself, Judge. I know you're never going to see this, but you should be ashamed of yourself. Be above this, you petty little son of a bitch.
I hear you on that, really do. But after that representation was made, she made another filing on the 4th, which was sufficient to meet her burden under the clear and strong and clear evidence, which you take as truthful. That was the straw that broke the camel's back that issued the temporary injunction.
Well, not really.
No.
And maybe Mr. Hales needs to be aware of this law also. As a matter of law, the court has to take what's pled in this petition or supplemental petition as true. When a petition results in entry of a temporary injunction with a return hearing, that means there's been adequate information contained within that petition to establish the imminent threat. If it's scheduled for hearing without temporary, that means there's a sufficient case to be resolved and adjudicated by the court, but the element of imminent, you can conclude, was not in the petition itself, the initial one in September, was not in the first supplemental petition, and only became adequate, legally adequate, addressing the issue of imminence in what was the second supplemental petition. So the issuance of the temporary injunction was the result of the finding that the allegations in the supplemental petition, when taken as a whole with the previous supplement and the previous petition, established imminent risk. And thus the court had no choice, because I have to accept it as true, and so on. So,
But not subject to cross-examination yet at that point, or not, correct? So it's taken as true without any
right,
cross-examination.
that's why we're going to have a contested hearing with full due process post
When?
multi-hour deposition.
When are we going to have the
That was
contested
brought
hearing?
rule that now is on video, broadcast for the entire world to see, that's caused reasonably caused embarrassment, humiliation, potential.
Why would her deposition cause embarrassment and humiliation unless she did something embarrassing and humiliating?
You are not a nice person.
Danger, at least there's allegations of that, and a huge fallout.
Oh no, he's not been removed yet.
Your Honor, what happened to the deposition?
They're
is
taking it up to a
court
higher
took the
court.
Fifth on substantive issues.
So when a pro se litigant takes the fifth, you think they really understand? There are
Judge, Judge. Is this on, Judge? You can't say as a pro se litigant, do you really think she understands what taking the fifth is? You, at a previous hearing, you warned her that she is going to be held to the same standard as a reasonably competent lawyer. So if she doesn't understand what it means, that's on her. If she does something improper like that, that's on her. If she says the magic words, I plead the fifth, well, in the civil hearing, you go, okay, fine. And you can stop questioning her, and the judge can draw a negative inference from her. In criminal cases, you're not allowed to use someone's Fifth Amendment plea against them. Like, oh, they refuse to answer. So you're not allowed to say, oh, because they didn't answer these questions, because they pled the fifth, then we think they're guilty, or we think that it means they admit they're doing it. You can't do that in a criminal trial, but you get to do that in a civil trial, in a civil case. If you plead the fifth against certain things, your refusal to answer those questions can be used as a negative inference about your case and about your arguments. And the fact she is throwing around the magic words and doesn't know what they mean, that is entirely on her. And the judge said she was going to be held to that standard. And now oh my Lord, Judge.
There are lawyers that make objections in this courtroom that are overruled probably 100 times a week. It doesn't mean they're acting in bad faith, but reasonably one could expect they understood. When they say hearsay, they understand the hearsay rule, but a lot of them don't, or the court disagrees with their view of it. Pro se litigant is held to the standard of a reasonably competent attorney, and reasonably competent attorneys make arguments that don't fly.
A reasonably competent attorney would know what the Fifth Amendment plea means in a civil case. Come on, Judge. You're not saying that it's a super amazing lawyer. Only super amazing lawyers can appreciate what pleading the fifth in a civil case means. Judge, that is so disingenuous.
In the face of case law or statutory, rules and rules of procedure, et cetera. So whether she's using it to say it's irrelevant, or using it to say I'm being annoyed, or using it to truly say it might incriminate me, I don't know the answer to that. What is relevant for today, and I'm hearing you say, is that by virtue of her doing so, you didn't get additional responses that you would otherwise believe you should be entitled to.
Yes.
Yes, Judge. And also, believe it or not, I actually took the time with her at the deposition to look at the Fifth Amendment, understand, so we're on the same dictionary, if you will. When she says the Fifth Amendment, what does she mean? That's actually part of the transcript.
Oh, good. So we didn't see that in the deposition video. So they actually said, you keep using these words. I don't think they mean what you think they mean. Let me show you what they mean, and show her. And so she did understand it, Judge. Jermaine Down. Thank you so much for the super chat. Jermaine, Judge, can you show me on the doll where Mark Feather hurt you? Really? Oh my Lord. Feather has done some sort of psychological damage to this poor judge. Duncan, Idaho, has the lawyer even mentioned the fact that the court documents not being sealed makes their online publishing practically a foregone conclusion? No, he hasn't. He hasn't really been able to get much in edgewise. That's part of the problem. Oh, we got 931 likes, 69 more. Oh, what a great number. No, wait, never mind. Sorry, that'd be 71 more. Sorry, lawyer math. 71 more. That'll get us no. It's 69. Now 68. I was right the first time. I should trust my feelings. Anyway, we got a few more to get to 1,000 likes. Let's get up to 1,000 likes. That'd be fun.
Giving her advice?
No, I said, here's the Fifth Amendment. How do you, when you
So
say,
you're expecting a pro se litigant?
She got it right,
There are lawyers that
Judge.
come in front of me that don't understand the Fifth Amendment.
but she got it right. She got it right. And she also said she had talked to counsel on the record about taking the Fifth. I don't know which counsel that was.
You think you would be entitled to that? To get her a pro se litigant in front of you at a depot to disclose what would otherwise be attorney-client privilege?
No, she said it on her own. I talked to an attorney. He said, this is take the Fifth, and it's on the record. So she did understand it correctly. It is a problem. She made the statement under oath. She took the Fifth under oath, and there's consequences to that.
There is. She said the magic
As far
word.
as this, I don't disagree that we need more time to hear our motion today. That's acceptable because again, we have a forced continuance here. Mr. Cook's depot needs to be taken. And
So let me ask you this.
Oh my God,
I
Judge.
need maybe an hour more with her.
Your Honor, I have, what was elided from the motion and memorandum they filed is that after I filed my limited notice of appearance, which did include a note not only about the continuance, but about potential discovery matters, I did formally, I emailed in writing Mr. Chockett, and I did make a motion under 12.310D to suspend both depositions. Again, the deposition of Mr. Cook can be cured if they just figure out how to serve him properly. As to my client, I wasn't even aware at that point that Mr. Hales was going to do what he did yesterday evening and plaster that video all over YouTube. I kind of suspected it. So I wasn't aware of that at the time that I made the initial 310D motion. That is an additional ground for my 310D motion. And before a deposition of her resumes at all, if it resumes, I think the court needs to hear that. So that I think is going to have to be left for another day, which is another reason why this case ought to be continued.
Judge, here's the problem. I already said the continuance, it's forced on us. But more important, there was a pending deposition. She agreed on the record pro se to continue it tomorrow at 11. We left it around 5:30 or 6. No motion for protective order was filed. Nothing was filed. And this comes from someone who, Judge, as a pro se litigant, who knew to file a motion to reschedule her deposition or to continue it. Nothing was done.
Tell me
You ordered
what
it, Judge.
impact, if any, you believe that subsequent to that. So if you made that argument to me the day after, or the day after that, or the day after that, or let's say any day before your client publishes on the internet for the world to see a video deposition that was not properly in conformity with the rule even noticed to begin with. So do you think that that has some impact on the court's determination of whether this deposition continues?
It has impact.
Okay. And it's detrimental.
It has negative impact.
Okay.
But you have to weigh that, Judge.
I'm weighing it.
Okay. All right. Thank you. And again, as far as the
Well, let me
26th,
ask you this too.
Oh my
Are
God.
there excerpts?
Let the damn guy speak, Judge.
So I look at a filing again late last night, which is effectively this morning before this hearing, of it appears to be excerpts of a deposition because it's like page 5, then it's page 12, then it's page 40, then it's page 60. So it's clear excerpts. And again, in conformity with the rules, 1310, 12.310, subsection 3, a copy of a deposition may be filed only under certain circumstances in conformity with the rules of general practice and judicial administration 2.425 and in conformity with rule 1.280G, which would require filing with good cause and with minimizing all sensitive information. Was that done?
I believe, yeah, those are
What?
her answers. That's why there was excerpts, Judge.
So under, hang on a second, let me get. Under 1.3103B, if what you're both representing to the court from different perspectives, understood, that the deposition previously taken, or let's call it part of the deposition previously taken, is necessary for this court to review it, then under that subsection, the court can order the complete deposition transcript to be provided to the court. And it would be conditioned upon it being under seal, and it would be conditioned upon it not being broadcast.
Boo! That's why we can't. So that's why we can't see the full 7
There was also
hours.
The issue that, again, I wasn't at the deposition, but my client tells me, I asked her about reading or waiving, and she indicates to me that she informed Mr. Shockett that she wished to read through the deposition and have the opportunity to complete an errata sheet. That was not done. I don't know why a deposition or parts thereof are being selectively put into the court record for this court and for the public to read, when one, they're claiming the deposition has not concluded yet, and two, she has not been given an opportunity to read it and sign off on it or complete an errata sheet, at least as to the initial portion.
Mr. Zimmer wasn't here. We addressed that with Your Honor. She had until, I think, today to do an errata sheet.
She wasn't even asked. The court
Yes,
reporter
she
never
was.
contacted her.
It's on the court reporter. She gave an email address on the record, and I can find out if the court reporter gave it to her. But
And-
that was on the record. I
If she
just,
had until today, why was the video plastered on the internet last night?
And posted.
Why
We
was it
don't-
put
we
in
don't-
this
we don't
meeting
know.
last night?
we don't know what happened with the errata sheet. I can find out. I'm sure it was sent to her. I
No,
never,
but
this
we
court reporter,
We do know that what you just said is that she still has time to do the errata sheet, and instead, a not properly noticed video deposition has now been posted, and excerpts of the transcript have been placed in the court file.
understood, Judge. And I understand what you're saying about a negative inference as to whether the debit goes forward.
What's your sense, Mr. Shockett, as to the request in effect that if it can be continued from January 6th, that
26th?
2 weeks or so, excuse me, January 26th, yeah, that if it's to be continued from that date, the court would be proposing February 9 as the date. So that's basically a 2-week continuance.
I think the fact that Mr. Schulman's here, the deposition will conclude very easily of Ms. Preston. I think that Mr. Cook's deposition can be taken in a half a day. And if he wants to take my clients, I think he can, I don't know how much time he wants for that, but I don't see it as insurmountable, except for this issue with the errata sheets. Again, we should address it the same way we did with Ms. Preston and Mr. Cook. Give a short window.
Let me ask Mr. Silverman, do you have a sense of how much time you think you would need on the deposition of the respondent?
I would think I would need 2 to 3 hours, probably not even quite that much, Your Honor. We're talking about a hearing that's only supposed to last another 2 or 3 hours. And so, first of all, let me say to the court, I'm available all day on Friday, February 9th. Let me just triple check that. I'm available all day that day. The boss tells me I'm available all that day. The second thing I'll say is that at this point, unless the court specifically orders otherwise, I do not intend to have my client sit for any further deposition. As to Mr. Cook, if they can figure out how to serve him properly, more power to him. And I'll certainly accommodate that. I will also tell the court and Mr. Shockett that I will do evenings, I will do weekends, if we can find a court reporter who will do that, to accommodate.
I'm beyond dumbfounded. I just give up today.
A reasonable period before February 9th, so both parties don't have to come out of pocket an outrageous sum of money for expedited transcripts. But again, I'm not conceding that my client is going to sit for any further deposition for a variety of reasons, many of which we touched on this morning, Your Honor.
Your Honor, if I could, on the calendar thing, I have a case in Dade County, and it's a 2017 insurance case, 2018 case. And the court's indicated that I have a deposition of my expert. And that court indicated that it's going to go to trial in March when this expert deposition finally is taken. It's on the 9th that day. I'll leave it to you. If you want to give me something that says to this judge, I can,
Your
change
Honor,
that depo.
my client and I are willing to accommodate Mr. Shockett because he has another obligation on that Friday.
Very nice
I
of you.
can tell the court that I can make the following Friday, the 16th of February, work. correct? My child has a doctor's appointment that day. I will have it rescheduled.
The court,
Is Friday the day we do it? Is that,
I'm sorry?
is Friday, it's just Fridays? Is that how it is?
No, it's just what the court can accommodate.
Right.
The next day I was going to suggest is February 5. So that's civil trial. That's a full civil trial week. The reason why the court has those 2 days available is because the civil cases scheduled for the month of February have settled. As a result, this court now has a full day trial on the 6th, a full day trial on the 8th, a half day obligation for the domestic violence docket, the court issue meeting, summary judgment motions, and a bunch of other things. And it opened a week or two ago. It's 3 days of now full. The 9th is available and the 5th is available.
I can do the 5th. I have a deposition. That's a regular one. I can reschedule that.
Your Honor, I can do the morning of the 5th, the afternoon of the 5th. I'm in a multi-hour hearing with Judge Fiegel in Dixie County on a child abuse case that has been specially set, so I can't move that, but I am available in the morning.
Let's go back to talk about the 9th regarding, because here's the other thing is I want to provide a little more time rather than less time, which is why I suggested the 9th first. Mr. Shockett, what's the deposition you have to take on that day for the expected
Yeah,
trial?
it's an expert deposition. He's a University of Florida engineer.
Are you doing
and-
that by Zoom, or
It is by Zoom.
so you're going to remain somewhere here, not
Yeah,
having
in
to
the
go to
Trenton. Yeah. It's set for 10 a.m.
I can, on the 12th, should we continue the trial?
I can tell you this, that the next full day, despite the fact that, again, back on November 29, the court had previously scheduled matters for the 30th, but felt it important enough to both litigants to offer that day, and the record would reflect. I said I would cancel what I already had, and I would accommodate these litigants, and that was denied. And literally, there's not another day, and I'm just in abundance of caution needing a full day for this till March 1, and that's just too far out. So
I can make March 1 work, Your Honor.
Well, probably we all could, but the consequences of time that are reasonably expected based on the negative consequences to the fair administration of justice, the orderly administration of justice, the compliance with rules promulgated by the Florida Supreme Court and the Chief Judge of the Eighth Circuit being violated, the court has concerns about the length of time and what might happen between now and then.
It would be, and I certainly understand the court's concerns, as I indicated in an email to Ms. Cummings, Chief Judge Mosley's JA, on which Mr. Shockett was copied. I can't be here next Monday for that. Chief Judge Mosley indicated that
I
my
can't.
client or I need to be here, and quite frankly, we don't have a dog in that fight. That's between the courts and Mr. Feather. I will hopefully think those order to show cause proceedings have impressed upon counsel the need to protect and comply with the videos in accordance with the administrative order. Certainly, if depositions go forward in this case, regardless of who the depositions are of, I will be asking the court to impose a protective order barring any publication, period, except in accordance with the rules of procedure. So I think we could address it there. As I indicated, I can make the morning of the 5th work. I do think that's likely too soon to get everything accomplished. That basically gives us a week to get the depositions done, and I will certainly endeavor to do that, though it does look like it'll have to be in the evenings or on the weekend to get those depositions done. Alternatively, if they're okay with the 1st, I can make that work as well, and that will give both sides plenty of opportunity to conduct the discovery. Hopefully, Mr. Hale's side of the aisle has gotten the message regarding the need to safeguard witness testimony, information, and evidence.
I can make the 1st work by moving things around. It's really weird. If someone doesn't go to the doctor very much, I actually have an appointment. It's not life-threatening. I'll just change it.
I'm more inclined to do the February 9 if you could otherwise accommodate that day.
Okay, I can just ask this other judge, Cheeseman is her name,
Okay, and they can reach out to this court.
if we can reschedule it.
So
But if absent that judge, I just know this is a 17 case. I don't think she's going to.
here's the other issue that your client needs to be aware of from the court's perspective and consistent with the statutory provisions that mandate upon continuance for good cause, the terms of the temporary injunction will remain in effect.
Can I be heard on that, Judge?
No.
So,
Wow, surprise.
you mentioned about the totality of the circumstances. Each pleading, each petition has its say 50 pages the first time in September, 334 pages in October. Each time it's weighing. The December 4th one, as you said, cumulative effect was the barrier, her burden of proof was reached in order to effect, which I think it's strong and clear evidence. I think that's the language for ex parte.
On the issue of imminent,
Eminent,
which
okay.
was
Okay. But
not
what's
sufficient.
happened, but that was still subject to cross-examination. She's been asked questions under oath, and she's taken the fifth. And I think at that point, there's negative inference to make. And please, Judge, this is important because now I think at least that, plus the fact that a continuance was effectively done by not allowing the depositions that you ordered, not just her, Mr. Cook on the 17th, no show. I think now you have to at least take the fact that she took the fifth, the subsequent questions, say maybe that lowers it so that we don't reach the burden of imminent and the evidence, her burden has not been met.
Yeah, but since that time, so then part of the nature of the initial complaint to be adjudicated by the court is the dissemination publicly of broadcast images and documentation, videography, whatever it is, about her that she's claiming is causing her substantial emotional distress. That's to be decided by the court at some point when I get all the evidence.
Right, but Budlove says that you can still use their name. You can do that as long as you don't have unprotected speech. That's, insightful, fighting words.
And I'm the one that not only narrowly tailored it before the Budlove decision, the court then in conformity with that decision modified it again for your client's benefit in conformity with the law. But it's another one of these balancing things, which is 2 more weeks of your client having the temporary injunction. But what I'm saying is what's happened since entry of this injunction, here's the totality of the circumstances.
Okay.
On November 29, his attorney, your co-counsel, when the court said, I will accommodate the litigants.
Oh my
I will
God.
cancel what I have. We can
Again
come back
with
at
this.
9 in the morning. That was 5 p.m. the day before. Your co-counsel said the following, quote, this was on 11/29 at 4:53 and 15 seconds to 4:53 and 47 seconds. No, Your Honor, Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning. That's what was represented. That's what gained your client a continuance. That was a misrepresentation because on 12/6 at 1:33 and 49 seconds through 1:43 and 45 seconds,
It's just
current counsel, Mr.
Judge.
Shockett, yourself, and questioning of Mr. Hales on a compliance issue established that he did not have a court appearance the following morning. That in fact, he went to Ohio to sign documents 2 days later in his lawyer's office. That's the first continuance gained on misrepresentations to this court and less than candid representation.
No, Judge, you're
Then,
absolutely wrong, Judge.
12/1.
I can't even yell
responded second
anymore. I'm
motion to
just
continue
so wiped
by
out.
Mr. Feather, which was inadequately pled, was filed at the last minute, did nothing to establish that it was something that arose between him agreeing to the date of 12/6 and the date that he filed this second motion to continue on 12/1. It did nothing to say that something arose unexpectedly that caused him not to be available. And it resulted in then you filing a notice of appearance and saying 24 hours and 20 minutes earlier, I need
Oh my God, Judge, you and these damn time stamping is getting on my
prepared,
nerves
which the
too.
court again accommodated for Mr. Hales. And Mr. Hales, as I mentioned earlier, hired an attorney he knew could not be prepared. He knew he had a calendar conflict or at least time conflict to be prepared adequately. And he was accommodated. I've got no regrets about that decision. It's in conformity with the law and the circumstances. But the circumstances then included on 12/5, third motion to continue of the respondent.
I think that's mine, Judge.
That was yours.
Yeah.
Okay, that was right. So
I'm
they were like 3
broken
days apart.
today.
We heard it on the same day. One I resolved outside the presence of a hearing, which was Feather's motion. Yours we did at subsequent hearing. The fourth motion to continue was the January 4. As I said before, in hindsight, the court felt it was error to allow that, as effectively we were midway through trial. Addition to that, and you guys are very well aware, and these matters are currently under investigation by the state attorney and or the Levy County Sheriff's Office under their obligation under Florida Statute 784.0487. 12.6, there's an allegation for violation of the injunction, which implicates you, Mr. Shockett. 12.27, another motion for contempt. 12.29, additional motion for contempt. 2 of them on January 2nd.
Hey, Beans 91 says, are we on repeat? We're not on repeat. The judge is on repeat. The judge is just locked in a damn loop. November 29th, 15 minutes. Ohio. It's lather, rinse, repeat. This judge. Today is the worst. I expected it to be a little better. I don't know why I expected it to be a little better, but I did. Today's the absolute worst. And we're going to be shutting this down real quick because I honest to God am just drained by this. This judge has sucked the life out of me today. I can't even be angry anymore. I'm just an empty shell of my former self because of this.
There's now contempt proceedings ordered to show cause on Attorney
Yes.
Chief Judge of this 8th Circuit.
Say Chief Judge of the 8th Circuit one more time.
In addition to all of those moving parts and developments, this court, again to accommodate the respondent, and again in conformity with the law, this court had previously narrowly tailored the language because there was not any, and I pointed this out in December, I pointed this out, I believe, in November, there were no DCA opinions subsequent to the October of 2021 statutory change, which added 6 words. And as I pointed out in the footnote in the case of Strober versus Harris, 2nd District Court of Appeals, when they remanded it back, they said, oh, by the way, the statute changed, implying that you need to maybe reevaluate this as a trial court in light of that statutory change. Nonetheless, the court narrowly tailored it, again, in conformity with Bud Love, decided by the 2nd DC on December 29. I modified the language again to accommodate him and to not restrict in the balance of things his First Amendment rights. Since then, we now have the posting of unredacted court proceedings from November 29 and 12/6 in violation of Supreme Court orders and this Chief Judge's order. We now learn today, this court now learns today, that there's also been publication and broadcast of a video deposition that was not taken in conformity with 12.310B4 and which has now been disseminated to the public.
Okay, this is we're a little over the halfway mark here. We got about 30 minutes left. We'll do that tomorrow, and of course, dogs are just over here playing with some bones. So all that noise you hear, that's the dogs. Right. Let's take down the court here. Where are we at? Timestamp is 59:54. Let me make a note of that. So we know where to pick up tomorrow. 59:54. So here's what I want to do tomorrow. I want to let's see, get it all organized here. Nah, I like this view. Right. Here's what I want to do tomorrow. Finish this up, and then I want to go and look at some of the filings, some of the things she's filed in the court, and read what's on the pages. That's what I want to do tomorrow. We'll do this. We'll finish it up. Then we'll read what's been submitted. A lot of it's nonsense, but we'll look at some of the filings to wrap it up tomorrow. But he's just literally beat me down today. He's just been jumping up and down and stomping my soul for the last 2 hours. I'm just gonna go snuggle with the dogs and watch some stupid mindless TV for a little bit, then go to sleep. Yeah, this just shouldn't be happening. This is the worst it's been. it's getting progressively worse, not progressively better, as I thought it would. Gee, silly little optimistic me. Jim Schuler with a $2 super chat. Thank you so much. It's called a hearing, Your Honor, not a talking. And again, we've addressed this before. He's a former law school professor. He clearly likes being a law school professor. He's an adjunct professor at the University of Florida, I believe. But he likes to lecture. He's a judge. He doesn't judge. He lectures. They're not there to be lectured. They're not there for a law school class. They're there to present you with a motion, supporting arguments for or against, and waiting for you, the judge, to be a judge and judge. Not to give a criminal law lecture or a civil law lecture or a rule of evidence lecture. Duncan, I don't thank you so much for the 10. I don't understand how no one has mentioned that it is the public's right to access all unsealed court documents and depositions. How is such a recurring issue? Has the whole world gone crazy? Yeah, pretty much. I guess the world's gone crazy at this point. I know I am. I know I have. I've officially lost it today. I was really, really optimistic about not being shouty, and this has been one of my rantiest days ever. Like in my entire YouTube history, I think this may be the cursiest, rantiest day I've ever had because I was just pushed beyond the limits. And Duncan, Idaho. So if I appear pro se, but I'm stupid and crazy enough, and the judge thinks I'm cute, no, and then they sort of find me not contempt, but only when it benefits me. Good to know. Got to work on my crazy. Yeah, I hope the judge doesn't think she's cute. How can he teach the law when it seems he doesn't know it? Well, we had a saying in law school. I believe it was my civil procedure law professor that said it, and a lot of people have similar sayings. Like the A's become professors, the B's become judges, and the C's become successes. That's an old saying. Jeff needs a Snickers. Jeff just needs to sleep. All right, people. We've cleared off the super chats. We've cleared off everything here. We've put you through 2 hours of torture. And there's still 1,200 of you here. We're going to go on over to Megan Fox. Megan Fox is going to be talking about a very, very interesting and disturbing case out of Georgia today. So go over there for more frustration, more anger, more righteous indignation. But let's cut you loose here today. And we'll be back tomorrow. We'll finish it up tomorrow. We'll look at some of the filings tomorrow. Wednesday, we're going to have a very, very special case. We're going to be doing some more follow-up on the Virgilio Aguilar Mendez case, the Guatemalan who was released, who the charges against him for aggravated manslaughter of a law enforcement officer were dropped because they just decided that, he'd been declared incompetent to stand trial. And plus, there's a little bit of dying of natural causes going on with the police officer. He was taken into ICE detention, but he was just released on an immigration bond pending his upcoming hearing. So he's free out and walking the streets. We'll do a little bit of catch up on that case. Thursday, we will be wrapping up the O.J. Simpson case, or with the final installment of the final closing arguments. And we'll get the verdict. And then a week from this Thursday, we'll talk about more stuff. And this Friday night, either Friday night or Saturday night, Danny on Direct, Flux and I will be doing an unexplained stream where we do that every now and then. Every couple of weeks, we do an unexplained stream where we talk about things that are unexplained or interesting, or we're going to be talking about Bigfoot and other cryptids maybe this week. Bigfoot and other creatures out there. We might be talking about that this weekend. So stay tuned for that. All right, let's go on over to Megan Fox, see what she's doing. And if you're on Replay Crew and you've watched this whole thing, just do whatever you want to do. We'll talk to you later. We'll see you tomorrow, same time, for the conclusion of the fourth hearing. Thank you, mods. Thank you, chat, for your support. Thank you so much for smashing that like button. We got up our 1,100 likes. We picked up a bunch of new subscribers. Please like and subscribe on your way if you haven't done. So you guys are great. I appreciate the support. Love you all. Thanks for just being here in chat and keeping everybody company. Good night, dogs. Good night, chat. Good night, mods. Good night, me. Good night, Moon. Good night, Judge Thomasis. Good night, Tortoise Lady. Lorax saying peace out.